to the court and prove to a jury that there is a breach of the agreement called the settlement agreement mutual release, and I had a right to injunctive relief to stop the petitioning activity of the defendant's ABC. That was part and parcel of the consideration exchange in the, we're going to call it the SAMR, settlement agreement mutual release, and go right to trial. Thank you, Your Honor. And if I could return to my short summary, is that the May 2023 decision and order was a complete surprise from far left field, and ignored this court's 2020 opinion, ignored the same judge's 2018 decision and order, ignored the 17 pages of summary judgment second filed by ABC, and concerned itself with really 1.5 pages of the assignability of a right of refund. And in fact, we have a simple case before this court and the court below: breach of agreement, or the SAMR. The CHO's made and gave important promises to ABC in the agreement. The CHO's rights included the right to alter the ratio of hotel units to residential units, and this right was a crucial part of much consideration that I'll explain soon, included the $400,000 paid to ABC. But in ABC's opposition brief, they failed to explain why the SAMR is too vague to allow the CHO's to enforce their important right to modify and use Alupang Beach Tower consistent with the SAMR. The SAMR is obviously a very detailed and comprehensive settlement negotiated by the best lawyers on Guam at that time. The SAMR is not void for vagueness. We have 4 reversible errors. 1, in the 2023 May decision, the court completely ignored the file complaint of the CHO's and the record that shows the complaint count 1, first count for injunctive relief, and separately the money damages that are in counts 2, 3, and 4 that were all dismissed in the entirety of the case. Reversible error 2, denial of a Rule 59 motion, where we took pains to point out to the court it's making a bad mistake here. And in response, the court says, the accusatory finger, we've abandoned our injunctive relief claims. We are hard put to find where that abandonment occurred. As the court will see here in the Supreme Court, there is no abandonment anywhere in this record. Reversible error 3, the CHO's had standing to file a complaint.
Yeah, Mr. Berman, addressing the standing issue first, the argument that's made is that the trial court conflated the standing requirements for the right to enforce their provision in the contract. Can you explain that a little more for me?
Yes, Your Honor. The decision and order, as I read it in May 2023, simply went far afield from the actual second motion that was filed, that was seeking to limit one part of one money damage claim, which was the right of refund, and completely ignored the injunctive relief that had been part and parcel to center focus of 5 years of litigation before this court and the court below. And the conflation is taking a finding, which we disagree with, that the right of refund is not assignable, and just twist that into a complete dismissal for lack of standing for the attorney's fees claim to fight the anti-SLAPP effort that was below and above, taking tremendous resources, the discovery that was sought on the anti-SLAPP, the discovery that was sought on the injunctive.
So what should have been the proper analysis for the court to make to determine if the CHO's had standing to file the action in the court? What should have been the proper analysis? You say that the court should not have focused in on a provision in the contract to determine whether or not there is standing in the case. So what should have been the proper analysis of the court?
Thank you, Your Honor. Speaking obviously candidly and frankly, I think the 17 pages that the second motion for summary judgment asserted should have been addressed in our opposition to it.
Well, that goes, I think, to the abandonment issue. I don't necessarily see that as analyzing whether or not the principles of standing that we have announced in prior decisions were applied. And so I'm asking you, how what would have been the correct analysis, in your opinion, for the court to apply to determine whether or not the Chos have standing to file the complaint in this action? Because the decision of the trial court is that the Chos didn't have standing because they did not have the right to step into the shoes of Hibari in order to be entitled to the 400 whatever sum of money. And you said that was error. And so what would have been the proper analysis?
Thank you, Your Honor. The first step in the standing analysis would be, is there a genuine issue of material fact? And our two declarations asserting assignment with backup contract documents called the purchase sale agreement stops that train on the tracks.
But
you don't go any further when you have a disputed question of fact.
That's a summary judgment issue. Justice Carbolito is referring to standing. The court found they didn't have standing because they didn't have the right to the claim for restitution, the right of the refund, and therefore didn't have standing to enforce the damages portion and dismissed it on that basis, granted summary judgment on that basis. But if the court was wrong or even correct, for example, that they didn't have standing on that claim, you make the assertion that there are other causes of action. So I think what the focus is what should the trial court have looked at in terms of standing and whether your client had standing to enforce any of the contract's claims, other than the portion that he determined they didn't have a right to enforce.
Thank you, Your Honor. The analysis I would have expected of the court would take two steps. One, procedurally, this is a motion to dismiss if you're bringing standing. And what's the response to motion to dismiss? If you have declarations and evidence, you bring it. That's procedure. On substance, we have the settlement agreement mutual release, the SAMR. And the SAMR has multiple grounds of consideration of property rights exchanged, given to Chos and given to ABC. And the Chos are a direct party participant. They're signers on the SAMR. They're not assignees. They're in it to win it.
Right. So you're asserting that they have a cognizable interest in the contract's promises, and an alleged breach of that is a legally sufficient interest to confer standing on them.
Really, Your Honor, overwhelming interest. I point out in my brief 6 separate points of consideration, separate and apart from the right of refund. 6 different places of abundant rights and duties exchanged by ABC and the Chos. Access rights granted ABC across the property, parking defined for ABC, Chos individually assumed to pay certain obligations for common area fees. Chos agreed to not object or assert any claims related to business operations of ABC. The Chos limited their claims they would assert not only to the type of business ABC itself could conduct, but also to any business 25% owned by ABC.
Let me ask it this way, Mr. Berman.
Yes, sir.
So in prior cases, we've announced that in order for a party to have standing, at least in terms of and we've adopted the constitutional standing in the federal courts, there must be an injury in fact, there must be a causation, and there must be redressability. So when you are arguing your general theories in reference to how the Chos should in reference to the Chos's interests in the case, how do you apply those elements in reference to the issue of standing? In the test that we have announced, it's pretty structured.
Yes, sure. I believe those elements you've just articulated are the proper ones to examine. Injury in fact, no question, Chos are injured here.
How are they injured?
Well, the complaint spells out there had a GLUC amended HPR that was the source of the objection letter and petition of ABC to stop it in its tracks. And the amended HPR was never granted. It was never allowed. And so all the lost profits that flow from 2016 to today are claimed in counts 2 and 3 in the complaint. That's just the beginning. And enforcing their right of injunctive relief in count one is even heavier. They should never have been allowed to write that petition, and we stopped them to restrain them with count one. If they wrote back, they would not relent. They would not stop what they're doing. And that injury is manifest in attorney's fees and those costs that are incurred by Chose. So that's just, I think, summarizes the injury in fact. And the redress is a complaint in this court. And that's the procedure to a trial for a jury to obtain damages and injunctive relief.
And did the trial court did any of that in addressing the standing issue?
I don't recall the trial court examining any of that. I think he just examined the right of refund. That's really all they examined. That it was not particularly convincing is the quote from the decision order. That phrase doesn't belong in anywhere in a summary judgment. That belongs in a findings of fact after a trial. So that something is not convincing or particularly convincing. So he's completely misapplying standards of trial versus summary judgment, motions to dismiss, all going on at once. Thank you for the question. And that was my very point, that the Chose had standing to file their complaint for injunctive relief and related money damages based on the SAMR. And the ABC protest letter that is April 13, 2016, Exhibit 4 to the complaint. And we also submit reversible error number 4, that the right of refund in the SAMR was assignable. This uncontroverted declarations of Mr. Cho in 2 statements under penalty of perjury was not rebutted. There is nothing to the contrary. There is no evidence from ABC. It's weighed against what? Nothing. No declaration from Hibbery, no declaration from Mr. Kasperbauer, ABC. There's no deposition taken of Mr. Cho. No discovery was even requested by ABC, so they had no responses to attach to their second motion. Their second motion really is the equivalent of a motion in limine. It wasn't any kind of summary judgment motion, really. And in that light, you can understand where it was coming from. And the response to that was, these are genuine issues of disputed fact, and those issues that they're bringing will be heard at trial under the mandate of this 2020 opinion from this Supreme Court. That's the lens you look at the issues at trial. It wasn't to be sorted out in a motion in limine or this mistakenly labeled second motion for summary judgment. Now, the background of the case, your honors are so familiar from the opinion number 1. I'm not going to get into the details, but suffice to say that the purchase and sale agreement had closing on December 2023, and the Chose paid $13 million. And settlement agreement 2004, the closing is October 15, 2004. So the money is traceable. Where that money that goes to the $400,000 that Hibbery had, it comes from Chose. That would come out in trial when we have our trial date. The 2020 opinion from this court was spot on, not contested by ABC, that the agreement of ABC was that the tower project is a mixed-use commercial, residential, and hotel condominium, and that market or other economic conditions may warrant modifications to the tower project. 2016, Chose filed for approval of an amended HPR before the Land Use Commission. April 13, 2016, the ABC protest of 8 pages is submitted to Chairman Arroyo, and the amended HPR is not granted. In 2017, our complaint was filed. There's 4 counts, describe that in detail. And on May 19, 2017, the Chose attorney, that's myself, replied to Attorney Thompson to try to resolve the dispute. That was Exhibit 5 to the complaint. As I mentioned already, the number 1 reversible error was to completely take no observation or account of the 6 points of property exchanges going on in the settlement agreement mutual release. Those
well,
are
the trial court and Mr. Thompson argued at the summary judgment hearing is that you had the burden of raising all that in response to his motion for summary judgment for lack of standing. And the trial court was persuaded by Mr. Thompson's argument. So why is that wrong?
Your Honor, thank you for the question. I'm taking the question as asking me about the standing issue again.
No, we've
Nope.
left that now.
I thought we did.
We are going to the abandonment issue.
Abandonment
And-
issue.
Yes.
Oh, good. So the abandonment issue is completely upside down. So I don't know how or why the trial court could make any conclusion of abandonment on the record of this case. And the record is, I dare summarize it, saying it was our motion to compel discovery responses they wouldn't answer to, beginning at the outset of the case, 2018, May 7th, February 8th. And then after that, the arguments on the anti-SLAPP motion are heard in May. In 2018, decision order denying anti-SLAPP motion is filed, and the Chos have just prevailed. And what is it they're prevailing on?
So let me ask this, so we don't go far afield. My mind's a little focused on, is there a rule or a case law that says that in responding to a motion for summary judgment where an issue of race, for example, in this case, that there's a lack of standing, that in addressing that, you must also address all the other remaining claims that you have in the complaint? Because that seems to be what is suggested here.
Thank you, Your Honor. I do understand the suggestion of the brief on appeal. However, that wasn't the brief filed in the trial court. The brief in the trial court is 18 pages, in which 17 is revisiting the settlement agreement mutual release, and then it is too vague to enforce, which is the same content that was the petition for rehearing after they lost in opinion 1. That is what's going on. The one page that was about that right of assignment was just that one page, saying what we see here is not sufficient to recognize an assignment. So we filed declarations to show this is a genuine issue of fact, material fact that will go to trial. What kind of assignment occurred here? We have it in writing. We have a future receipt of money that can be assigned. We have a verbal assignment, which is enforceable under California law. And all those grant standing to the Chos to file a complaint for relief, both not injunct, but the money damages. If we're going to talk about the right of refund, that's the money damages side. But those money damages are separate and apart from all the other loss of profit damages and the attorney's fees and costs to get all the way to trial and prevail in the trial. So I hope that I put that in square light, that I understood their brief to be saying. I think their brief is expanding upon and trying to springboard off a very erroneous decision order that didn't even address their second motion except for one page. And there should have been no extension of the standing analysis to any claim other than the right of refund, which is our fourth argument of reversible error. In our arguments, we do explain to the court in our brief that this reversible error to dismiss all of the separate money damage claims is just that, reversible. There's no reason unjust enrichment should be dismissed, that the breach of warranty should be dismissed, that the breach of contract that included claims of loss of profit should be dismissed. Instead, what happened here is it was all dismissed, and the record will now show that attorney's fees that we were seeking are now granted to ABC in the amount of $100,000. Although it is very hard to understand how ABC prevailed in the 2018 decision and order, and just as hard to understand how ABC prevailed in the 2020 opinion to be awarded $100,000, but that's another day and another appeal. This first error that we're still talking about of the trial court completely overlooked our objection we filed the day after we had their submitted judgment. And we said in our proposed judgment, this does not dismiss all of our other claims. Your Honor's just talking about the right of refund. The next day, judge gave us no weight and filed the judgment to dismiss the case in the entirety, to our surprise. Again, dismissing counts 2, 3, and 4 that are separate money damage claims. The second reversible error, and this goes back to Your Honor's question, the abandonment. How is it that the Rule 59 motion we filed was denied? Well, the court found abandonment, said that we abandoned all of our injunctive release claims. Our briefs explain that the heart of an anti-SLAPP motion is exactly injunctive relief. The anti-SLAPP is saying, we have the right to petition. We have the right to protest and object to your Land Use Commission amended HPR. That's injunctive relief. we're on the other side of that saying we have a settlement agreement prohibiting you from doing that. You've waived that constitutional right. That has gone on from 2018 until the end of 2020 when the petition for rehearing was denied. So to say that we abandoned it is real irony. The heart of the second motion for summary judgment wasn't that we abandoned. It was the antithesis that we didn't abandon. We didn't abandon injunctive relief. So in March 2022, they filed their second motion for summary judgment to kill it. Had we not had our injunctive relief still on the table, that second motion had no reason to be filed. And in that regard, the Rule 59 decision should be reversed. The primary issue.
What about the other claims that are set forth in the complaint? Did the trial court address them? The breach of implied covenant of good faith and fair dealing and the unjust enrichment?
Thank you, Your Honor. My understanding of the decisions and orders is no. They were never covered, addressed, or analyzed, just glossed over. Continuing to our point about the settlement agreement mutual release, that it is enforceable by CHOS and allows CHOS to alter the ratio of condominium units to hotel units. It's ABC's basic repetitive argument that the SAMR is too vague and indefinite for enforcement, which I would have thought was resolved in the 2020 opinion, but they keep raising it. But the answer is the SAMR is enforceable because current Guam law and before the law provides that settlement agreements are construed according to normal contract principles, and Guam law should not be changed in that respect. And we rely on Shawrock v. McCoy and Wasson v. Berg. Settlement agreements are interpreted as normal contracts. Guam law does not require an enhanced level of clarity in a settlement agreement, even if it includes a waiver of constitutional right. We cited the court below and, to your honors, Duracraft, 1998. In the case of thousands of auto crash settlements on this island, those settlements and releases aren't worded at any heightened or intense level of clarity or scrutiny in order to pass an enforceable contract analysis. That's covered in Shawrock v. McCoy. All of those releases and settlements in just a plain auto crash are enforceable.
Let me ask you this. You both seem to suggest or agree that maybe provision 3.1 doesn't apply to the amended HPR. I mean, you were suggesting that if that was the case, it would give you a lower burden to prove that there were other provisions of the contract and would give enhanced clarity because there were other provisions on the contract that could be interpreted that to approve what you were doing today and need not be constrained by this materiality in all respects. And you seem to suggest that we can decide that as a matter of law based on the four corners of the settlement agreement. But when we remanded in the first case, it wasn't clear to us from the documents or even the details on the amended HBR whether it was the materiality provision applied, because it wasn't clear to us from the record, at least, that the changes to the replacement HPR, which was then amended later, were material or was covered by that provision. So, I mean, do you still think that we could make that determination just by examining the agreement?
Thank you, Your Honor, for the question. Yes, the general answer. That was what our brief had said expressly, that 3.1 was not intended to control a future amended HPR that caused this entire case to be filed. It was limited to the replacement HPR in the context of section 3.1. The future activity of ABC and the CHOS was governed by 3.12, and that really addressed the future. And the replacement HPR was before the parties at the time of the settlement.
But what about, I mean, yeah, that's your position, that's fine. But what about if you take the position that the amended HPR was not within the scope of the replacement 3.1, because that only applied to the replacement HPR, but there was also the provision that if there is something subsequently filed that was materially similar, that it would be within 3.1. So there's no argument that the amended HPR is materially similar to the replacement HPR, and therefore section 3.1 may apply.
Your Honor, if I may separate the question into the two parts in the SAMR, 3.1 and, as I was saying before, 3.12. 3.1 is entirely centered on the replacement HPR. It's, well, I should say there's other parts in the first two sentences that are not the replacement HPR, but at the bottom line or two of 3.1, that is talking about the replacement HPR or a document that would be very similar or similar to the replacement HPR. It's not talking about the amended HPR, which we submit is governed by another part of the SAMR 3.12 and the freedom of the CHOs to act in their business.
So what about the last part of section 3.1 that says the AB shall without delay sign a new replacement HPR or amendment to the HPR so long as such document is similar in material respects to the replacement HPR previously submitted to the Guam Land Use Commission. I mean, Chief Justice Torres was asking the question whether or not we can address this issue, whether or not the amended HPR is within the scope of 3.1 based on the language. But if the section 3.1 is similar in material respects to the replacement HPR, then wouldn't that come within the scope of 3.1?
Your Honor, 3.1, the last sentence. That's what we're on. Thank you.
Yes.
Yep. The reason why, among others, that we're submitting this is not related to the amended HPR is even the verse part of the phrase, if requested by Hibari or the CHO group, that didn't occur. There was no request of Hibari and the CHO group to even invoke this section. But if it did, ABC then shall, without delay, sign a new replacement HPR.
All right, I'm not going to labor. If you don't feel that's applicable, then that's
Okay.
fine. I'm
all right.
And what about the provisions of section 4.1 to 4.11 in terms of recognizing that that there may be conditions that may change, and that the representation that this is a mixed use type of development, and there may be market conditions. Those provisions don't apply in reference to whether or not the amended HPR comes within those sections.
Thank you, Your Honor. The one phrase that immediately resonates with me is that should market and economic conditions change. And that, in my understanding, is related to the amended HPR.
So wouldn't it be better in the first instance if the trial court addressed these issues when arguments are made in relation to whether there are other provisions in the HPR that may apply to the amended HPR such that it is then within the scope of the settlement agreement?
Your Honor's question, I'm trying to
because you're taking the position agreeing that we can settle this matter by just deciding whether or not the amended HPR comes within the scope of the amended of the settlement agreement, and both of you contend that 3.1 doesn't apply. I'm not going to argue if you both agree to that. But then the question in my mind after reading the settlement agreement, are there other provisions that make it such that the amended HPR still comes within the scope of the settlement agreement?
Thank you, Your Honor. I do believe the amended HPR is is authorized by the settlement agreement mutual release. So you have to look at that, and it is relevant. It is relevant to the amended HPR. We're only submitting that 3.1 was not the operative relevant provision, and the other provisions are the relevant operating provisions.
But did the trial court decide that, address that in the first instance?
My understanding is no, it did not get into all the provisions relevant, although it did touch upon changing economic and market conditions. I think that was in the decision in order.
Mr. Berman, you've exceeded your time by 3 minutes. I'll give you 2 minutes on rebuttal.
That's fine.
yeah.
Yeah, I did reserve 5, but
Yeah.
I'll take 2.
I know.
Thank you, Your Honor.
Well, we gave you 33, so we'll give you 2 more minutes on rebuttal. You'll have
Court is
5
more-
minutes over, and I'll give Mr. Thompson his
The
opportunity.
court is more than gracious. Thank you, Your Honor.
Mr. Thompson.
Mr. Chief Justice, may it please the court.
Mr. Thompson, can you just raise the microphone? Thank you.
Very well. Your Honor, lots of issues discussed in the briefs here, but the overarching issue is the question of the propriety of summary judgment. This was a summary judgment motion. We didn't move for partial summary judgment. We moved for summary judgment of the entire case on multiple different grounds. Yes, the issue of standing was the first issue we raised, but we also raised, as counsel pointed out, in the remaining 17 pages of the brief, a variety of different issues, basically talking about 4 corners of the settlement agreement. Now, when a summary judgment motion is filed, as this court well knows, it's incumbent upon the non-movement to come forward with what they have. It's time to put up or shut up. It's time to produce evidence.
But the basis of your summary judgment is that, or the primary basis of your motion for summary judgment is that the CHOs didn't have standing to be entitled to the reimbursement of the $400,000 because they didn't come within section 3.4 of the settlement agreement. Only Habari was entitled to that, and the court went off on that tangent, and that was the basis of the court's decision. So we need to address whether or not the court was correct or not on the basis of its decision for granting summary judgment.
Well, Your Honor, the court's correct that in fact that was the first argument we raised in our brief, and the remaining 17 pages addressed other issues. Now, the court did not address.
But that's discretionary with us whether or not we want to look for alternative grounds. But in my mind, the trial court made a decision based on standing, and so if the trial court's analysis was wrong, that the plaintiffs did not have standing, and that is reversed, then that motion for summary judgment then should have been denied on the issue of standing and allowed the plaintiffs then to pursue their claim.
Well, Your Honor, respectfully, we disagree because as the court knows in its recent decisions, the Dietrich decision last year in particular, that when a movement comes with summary judgment and moves on multiple grounds, as we did, it's incumbent upon the non-movement to respond to the issues that have been raised and to respond not just with argument, not just with references to the complaint, which is essentially what the CHOs did in this case. They said we pleaded injunction. Well, actually, they didn't even say that in their moving paper, in their opposing papers. So the burden shifted to take our second argument, which was actually the larger of the two with much more case citations, much more argument.
But the trial court didn't rule on that, on those alternative arguments.
That's correct, Your Honor.
At all. So it granted summary judgment strictly on the basis of the standing issue and the failure to pay the consideration in the first instance.
That's correct, Your Honor. But in this instance, we actually have the benefit of, if it accomplished anything, the motion to reconsider caused the court to issue that decision that said, What other issues? You didn't raise any other issues. There are no other issues in the case, and pointed out that there had been, in fact, an abandonment or a waiver. And as we pointed out, and the court adopted this, we found only one reference.
I'm just really perplexed with that, Mr. Thompson. You're a very experienced litigator. I mean, in reference to a motion for summary judgment, challenging standing, and the party addressing the arguments raised in the motion, that you're now saying that it was incumbent, without citation to any rule or case law, that they need to throw in everything and the kitchen sink in responding into potential arguments that can be made in response to the motion for summary judgment that the plaintiffs lack standing in the case.
Well, Your Honor, we cited to the court the Ninth Circuit's decision in Shakur versus Shiro. That case involved a pro se plaintiff prisoner who argued on appeal. He had an attorney at that point, and it was argued on appeal that, well, look, the other side didn't raise the fact that I have an establishment clause claim, and therefore I had no obligation to respond to it in my opposition to summary judgment. The Ninth Circuit wasn't impressed with that argument. The Ninth Circuit said, you had an obligation to come forward with addressing the allegations you raised in your complaint. Not enough just to plead those. You need to have argument and evidence to support that claim as a bar to summary judgment. The Ninth Circuit in that case said, sorry, it's not the duty of the movement to anticipate the defenses that are going to be raised to summary judgment. And even in a case where a pro se plaintiff, where liberal construction of the pleadings was involved, the Ninth Circuit said you have abandoned these claims because you didn't address them and you produced no evidence in support of them in summary judgment. And that's what the court clarified.
What about the complaint that was filed, the correspondence back and forth regarding the alleged breaches by the parties, the demand letters? You don't think any of those are sufficient to create claims that could withstand the summary judgment motion?
Well, no, Your Honor, because if I may, those documents and those arguments were raised only in connection with the anti-SLAPP or Citizen Petition Participation in Government Act issue that had happened 4 years earlier. In response to the summary judgment motion, there was one document. Well, I should say one declaration file, 2 pages.
No, but the underlying complaint in this matter consisted of 4 causes of action, right? The injunctive relief, the breach of contract, and for repayment of the consideration, which was the right to the refund, I guess, or the right of refund, and then unjust enrichment and good faith and fair dealing, right?
Correct, Your Honor.
So if that was the complaint and the trial court addressed one of those claims, which was the complaint for breach of contract in count 1, or for the return of the money, what happened with the other claims that were alleged in the complaint?
Your Honor, we respectfully submit that in response to our summary judgment motion, which sought summary judgment of the entire case.
But you didn't argue that you were entitled to summary judgment because those other claims that Chief Justice Torres referenced doesn't entitle the plaintiff to any relief.
Yes, Your Honor, and respectfully, as we cited in the Shakur versus Shiro case, the Ninth Circuit said we didn't need to. It's not our job to anticipate what their defense is or what to animate their claims and say, oh, well, here's our response to their pleaded claim for which they have produced no evidence. It's not our obligation to do that. On summary judgment, and when you move for plenary summary judgment, not partial summary judgment, but plenary summary judgment.
Although you may have entitled it summary judgment, plenary summary judgment, your papers was limited in reference to the grounds of summary judgment based on the return of that, who is entitled to that $400,000. And so while your argument that because you use that it's a motion for summary judgment, you didn't have to argue the reasons why the other claims in the complaint that the plaintiffs are not may not recover. That is I'm just I'll go back and read that Ninth Circuit case. You said it's a criminal case, but that will make it really an undue burden for the opposing party to guess as to what you are arguing other than what's stated in the pleadings.
Your Honor, if I may, I'd point to the record of the original brief we filed, the moving papers in support of summary judgment. And I think that review would reveal it's abundantly clear that yes, the first argument that we raised, only devoted 2 or 3 pages to, was the standing argument. The second argument was an alternative argument. It said, regardless of what you say about standing, Your Honor, look at the 4 corners of this document. And this is not sufficiently unmistakably clear to accomplish what they want. And that's what they sought in those other claims. They sought to bar the right of ABC to protest to a public agency. And so we did, with respect, Your Honor, we did address it as an alternative argument that went to all the other claims that were raised. And what the Shakur case says is
okay, assuming that I follow your argument and we decide that the trial court erred in its analysis of the standing issue because it conflated the constitutional standing requirements with an enforcement of a right within a contract, and that the plaintiffs then the chose do have standing to file the complaint. And the trial court did not address the other issues in your motion for summary judgment. How are we going to decide whether or not that's correct or not correct?
Your Honor, I think the answer to the question is, in this case, when we moved for summary judgment, and again, I'll submit we moved on multiple alternative grounds, it was incumbent on the plaintiff, the non-movement, to introduce evidence and argument concerning what they had pleaded in their case.
And how do we know they didn't introduce that evidence if the trial court didn't address it? How do we know that the evidence that was set forth in the 80 pages that accompanied the complaint when this action first was done, which included correspondence, a copy of the settlement agreement, correspondence showing the objections, ABC's withdrawal of objections, the stipulation of dismissal, the letter protesting the proposed revisions to the HBR, the demand letter, all of those documents. I mean, don't they plausibly establish a breach of the settlement agreement?
Respectfully, no, Your Honor. And perhaps as a matter of evidence, I should point out that unless I'm mistaken, that was not a verified complaint. And so none of what was attached to the complaint was actually properly before the court to be considered. So as a matter of evidence, when the summary judgment motion was filed, it's the obligation of the non-movement to introduce as evidence admissible evidence. Certainly not Mr. Cho's self-serving declaration about his opinion of legal rights to Hibari's refund. So we think that, frankly, we see it as a very simple case of not stepping up to the bar at summary judgment. And the policy purpose for that is clear. It's that this court would be constantly hearing appeals like this to undo summary judgments if the movement's entitled to a second bite of the apple. But when summary judgment is filed, that's a very serious matter. The non-movement must step up to the plate and say, here are all the reasons why you shouldn't grant summary judgment, Your Honor. And really the only thing they addressed, certainly with evidence, the only thing they addressed was the question of Hibari's right to refund, or their entitlement, allegedly, to that right of refund. And as we stated in the brief, that was not even admissible evidence. A landowner's opinion about the legal effect of a document that contradicts what he said, that's not evidence. The court used unfortunate language about not finding the declaration persuasive. Well, not only was it not persuasive, it wasn't evidence. It wasn't admissible evidence. The honors, I did want to refer to the court's Detry decision because that was just last year, and I think the court restated very clearly what the standards of the summary judgment are that actually apply to the new rule as well as the old rule. The court affirmed the summary judgment because the non-movement said, oh, there are disputed material facts. Look at our complaint. But it didn't set forth what specifically those disputed facts were. And more importantly, there was no evidence about what those disputed facts were presented in opposition to our motion for summary judgment. And the court said, you cannot merely rely on the allegations of the complaint. And with respect, that's what they did in this case. They didn't even mention that the pleading of these claims, that the claims were still viable. They didn't say, oh, we're still trying to get this approved, this HPR, and therefore we need an injunction. Not a word about that. There was no evidence of any oral understandings of the parties that animate contract interpretation. They basically defaulted on all the other issue except for their entitlement to Hibari's consideration. So they sort of made their bed and need to lie in it. I mean, it's not the duty of the non-movement to anticipate everything that might come up and to have to articulate every single possible defense. But at the very least, what they could have done is said, Your Honor, we pleaded several other counts for which we do have standing and which survive summary judgment. They just didn't do it. They could have done it. Could have done it. Now, I want to speak to the...
You don't think that's laid out in the context of their opposition?
I do not, Your Honor. I believe they made arguments with very little evidentiary support, well, no evidentiary support, and very little citations to case law, and just said, well, it's clear enough. These provisions taken are clear enough. But Your Honor, we can submit that it was said of us that ABC takes the view that you can't waive constitutional rights in a settlement agreement. We never said that. Of course you can. But the standard is an ultimate, a heightened standard. It must be unmistakably clear that you're waiving those rights. And if you look at the settlement agreement and mutual release, this court, though not interpreting the agreement, this court looked at it and said, it's unclear whether the amended HPR, whether the settlement agreement even applies to the amended HPR. It was unclear to this court on its limited review when looking at the anti-SLAPP motion issues. It didn't become any clearer. And why not? Because they produced not a shred of evidence about the interpretation of that document. They had the opportunity to. We raised the issue. We talked about it extensively. Where is the evidence? Where is the record? There was nothing really for the court, the trial court, to discuss because they introduced as evidence in opposition to summary judgment, a 2-page declaration with the purchase and sale agreement. That was their opposition.
So in reference to that declaration that referenced the settlement agreement and the purchase and sell agreement, so those documents then become part of the opposition, and it shows that number one, the Chos were parties to the settlement agreement, and that in reference to the purchase and sell agreement, the argument whether or not it'll carry the end of the day provides that they are pretty much stepping into the shoes of Hibari because they're purchasing the property and all the rights and appurtenances regarding the purchase agreement. So in reference to the declaration attaching those documents, couldn't it then be argued that number one, they have made a claim, show that they have standing because they have an interest to be protected, and number two, that the other claims in the complaint continue, those claims continue, and that the court didn't address whether or not that was not sufficient. I mean, the court just totally ignored it.
Well, Again, Your Honor, I believe the court ignored them because those pleaded claims for relief were not even hinted at in the opposition to the motion. It's not the court's obligation to set up the plaintiff's case, the non-movant's case for him. The court takes what it is given. And what it was given was a strenuous argument that we're entitled to the money Hibari paid. But not a whole lot.
What about the language in the opposition that says after substantial payments to ABC, some are granted the Cho side discretion to modify the ABC facilities doing market and economic conditions. And they relied on the defendant's waivers, releases, and promises of non-objection. And they cite Cho's declaration, citing at different paragraphs to their reliance on this and going back to all the parts of the agreement. You don't think that satisfies it?
No, Your Honor, respectfully, we do not. Maybe the way to answer the question is, like we say, it is certainly possible to waive a constitutional right to protest, but it has to be clear and unmistakable. How could it have been clear and unmistakable? They could have put a provision in the settlement agreement that said, you may not object to any HPR whatsoever of any kind into the future. Remember, this was 12 years after the settlement agreement.
Well, how do you, I mean, but they do point out other provisions in the agreement. And I think we even recognized in our decision that there may be other provisions of the settlement agreement that may be relevant to the Cho's claims other than the 3.1, which we said even that we're not sure applies. But they point out that there are other provisions that could do. In fact, he points out that even if they have conflicting intentions about the meaning of some of the language, there's the provisions regarding let me just find it, the specific sections of the agreement that they argue. They said that you agreed not to oppose any modifications to the zoning variants under 3.8. They'll have the ability to change the mix, that ABT was a mixed-use condominium, and that as long as it didn't affect the property where ABC was running its business, that they wouldn't oppose the occupation, use, and ownership of areas in which the plaintiffs occupied and used. And that was under 3.12. There was a provision under 3.10. So there were other provisions that they asserted. In fact, he seems to concede that 3.1, which the court, we weren't sure whether it could apply to the amended agreement. He's saying, no, it doesn't, but there's all these other provisions that do.
And I think the other provisions, specifically 3.8, 3.10, 3.12, if read carefully, none of those provisions clearly applies to this amended HPR.
Isn't that supposed to be determined at trial?
Your Honor, it would be if there was evidence in the record that animated such an exploration. There wasn't. We're stuck with the four corners of the document because they had a chance on summary judgment to introduce evidence that spoke to those issues, but they didn't. And because they didn't, it was appropriate for the court to enter summary judgment, even if it didn't expressly articulate that in its initial decision. Again, it's a matter of coming up with the evidence. Could they have done that? Could they have raised disputed material fact issues? Sure, they could, if they had had proper declarations, proper exhibits in response to this motion. Instead, they focused to their folly on that narrow standing issue about the right to recover Hibari's refund, and frankly neglected to address even their own pleaded causes of action as a response to summary judgment. And we respectfully, those three provisions, the courts articulated 3.8. For example, 3.8, it talks about regulatory permit filings pertaining to ABT as presently existing at the time of the settlement agreement. So that's a limited provision. 3.10 talks about types of business operations. Well, what does that mean? The dictionary, Black's Legal Dictionary, says it means day-to-day operations. It's not talking about a wholesale change in utilization of the property. So that's a pretty limited and unclear provision. And 3.12 talks about the obligation not to oppose operations in ABT. But again, it talks about existing uses, basically preserving the status quo. The amended HPR, which comes along 12 years later, proposed a very dramatic change. Now, what the settlement agreement didn't define was, what does similar in material respects mean? That wasn't clear. Now, the other side could have presented evidence which might have animated what the parties understood. They did not. So we're stuck with the four corners of the document. And we respectfully submit is, we don't have to prove these particular provisions inure to our benefit. We need to prove simply that it was not unmistakably clear as it was required to be.
What about the obligations mentioned in paragraph 4.1 to 4.13? It imposes obligations. For example, that ABC agrees not to object to or assert any claims related to the type of business operations conducted by the Cho Group or the association. Acknowledgement by ABC that ABT is a mixed-use condominium, including commercial use similar to those conducted. Agreement that market and economic conditions may warrant modifications to facilities within ABT. Agreement by defendants not to oppose plaintiff's occupation, use, and ownership of specific areas. Agreement not to assert any claims that any provision of the settlement agreement is valid or unenforceable under the HPR Act or any other law. I mean, the trial court never addressed whether these provisions covered the amended HPR and whether or not the amended HPR came within the scope of 4.1 to 4.13.
Yes, Your Honor. I think I understand Your Honor's is that the trial court did not undertake to make the contract interpretation in the first impression at the trial court level. We submit that it was not incumbent on the court to do that because the other side simply raised no evidence about contract interpretation. Contract interpretation in this case was the four corners of the document because there was no evidence submitted that was contrary to that of prior understandings of collateral documents that might animate.
But what the trial court had was number one, it had a complaint that had four claims in terms of breach of contract, injunctive relief, for the damages claim, for unjust enrichment, and for the breach of the implied covenant. So those existed. And then at the time that the motion for summary judgment was filed, the declaration was filed with the settlement agreement and the purchase and sell agreement. And so if your argument is that there needed to be additional evidence and it's and these provisions 4.1 to 4.13 made those assertions, and if in fact the amended HPR came within the scope of that, then wasn't there a need to address whether or not the amended HPR came within the settlement agreement and that the ABC was limited in reference to what it could raise? And
Well, I don't think so, Your Honor. I mean, again, this is a matter of contract interpretation that could be made as easily by this court as the trial court because of the lack of evidentiary support.
But what other evidence, Mr. Thompson? We have the declaration attaching these documents. You're saying it's a matter of contract interpretation. So shouldn't the trial court have to address in the first instance the argument that the settlement agreement and the purchase and sell agreement satisfies that the limitations imposed by 4.1 to 4.13 prevents it from raising these objections to the amended HPR?
I'm not sure I follow the question, Your Honor. The purchase and sale agreement, I think you referred to.
Well, the purchase and sell agreement says I'm buying your interest and includes all pertinences and rights. And the settlement agreement says that there are these conditions that will allow us to come back and possibly amend the HPR. And so there was an amended HPR filed. There was an objection that was raised by ABC. And so it's front and center before the court. If you've made the motion for summary judgment, that these documents don't entitle the chose to relief under the settlement agreement or restrict ABC from raising these objections. And if your argument is that that was not specifically argued by the chose, at the same time, when you're saying that there needs to be evidence more that they're entitled to relief, and that their ABC is not restricted from raising these objections because it doesn't come within 3.1. I'm saying there are other provisions that may apply that was not addressed by the court, and you're asking us to uphold summary judgment based on a decision that relied only on the standing issue and that did not address the other potential claims. And I just have difficulty with that.
Well, Your Honor, again, the trial court, when prompted by a 59E motion, ruling on a Rule 60 standard, but 59E is really what applies, it addressed that issue and found that there had been waiver of the other claims because they weren't even mentioned in opposition, let alone asserted, nor was there any evidence supported in animation of those claims at the summary judgment level. So that's why it occurred to the court that it was resolving the question, all the issues on the basis of standing, because it saw no other issues that were being raised in opposition to summary judgment.
But what about the declaration filed that the settlement agreement exists on the record? The chose stepped into the shoes of Hibari, and that there are other provisions of the settlement agreement that seem to limit the ability of ABC to object to the amended HPR.
Well, I'm recalled of the Ninth Circuit's famous pigs looking for truffles, that trial courts don't have the obligation to do the hard work for.
And I agree with you because we've cited that, but also you're asking that in response to a motion for summary judgment that seemed to be pretty focused, that the non-movement raise every single possible argument in relation as to why the entire complaint should not be dismissed when that was seemingly not the issue before the court.
Well, respectfully, Your Honor, I do think a review of our motion papers could make it clear. We definitely moved in the alternative, and we definitely sought plenary summary judgment of the entire case. And it was the obligation in response to such a motion, at its folly, the non-movement has to come forward with at least some argument regarding, hey, Your Honor, we have other claims. How about those? Nothing like that in the brief. No evidence submitted to animate those claims. Again, the record doesn't even show that the chose are actually still intending to accomplish what they sought to do 6 years ago when this case was filed. Is there a live controversy still? Do they still intend to proceed with this HPR? Not a shred of evidence of that. Do we even have a live case here? Is this?
But these are all hypotheticals before our court that is not in front of us.
Yes, Your Honor, that's my point, is that it was incumbent on the non-movement to make those live issues and to say, hey, we have a damages claim. Your Honor, you can't enter summary judgment. Hey, Your Honor, we still need this injunction because we're still trying to accomplish this development. The record's devoid of that information. It wasn't our obligation as the movement to come forward with that. It was their obligation to say, we still have live issues, Your Honor. Please don't enter summary judgment. That really wasn't there.
Mr. Thompson, let's say we reverse on the issue of summary judgment on the we say he made the wrong decision on standing. Are you arguing that then the rest of the case still remains dismissed? Or I shouldn't say dismissed, I'm sorry, that summary judgment as to the rest of the counts remains intact? And they can only litigate that issue of the refund?
Yes, Your Honor, I believe so, because the standing issue was, as the court has pointed out, was related to the right of refund. It wasn't a standing. I don't think in our moving papers, we did not argue that would resolve the entire case. And that's why we raised alternative arguments. But again, in response to those alternative arguments, we expected to see some sort of evidence to back up the claims they've made. Were we supposed to tell them how to defend their case and what evidence to produce? I don't think Shakur and other cases saddle on the moving party to make the non-movement party's case for them on summary judgment. Your Honor, if I may conclude, the Chos in this case had their opportunity to oppose summary judgment motion. They had ample time for discovery. There was never any argument to the contrary. There was never a 56F or D filed. They had plenty of time to do this. They failed to demonstrate any disputed facts. They said there were disputed facts, but there was no evidence and no specifics. They abandoned claims that they raised in their complaint, but never articulated beyond a mere passing reference in their opposition memorandum, and never produced evidence in support of any of them that we even knew there was a live controversy. The trial court's entry of summary judgment should be affirmed because while there are portions of this settlement agreement that arguably relate to the amended HPR, as this court pointed out 4 years ago in its decision on the anti-SLAPP motion issues, it's really not clear to what extent this applies. The prohibitions stated in the settlement agreement apply 12 years later to a rather different amended HPR that came along. It's a big leap, and we respectfully submit that the case law from California and elsewhere under our own contract statutes do indeed require a higher level of scrutiny when it comes to a proposed waiver of a constitutional right to complain to a public agency. Thank you, Your Honors. Unless the court has other questions.
No, thank you, Mr. Thompson. Mr. Berman, I give you 2 minutes to wrap up.
Thank you, Your Honor. May it please the court. In brief rebuttal to just what Attorney Thompson was arguing, I was surprised and say, wow, he's still arguing abandonment. Couldn't believe you heard that. Just look at the anti-SLAPP litigation. There's a 3-year stay on this case. They demanded. I opposed it. Just look at that. He argues time to put up or shut up, but he gives no weight to the declaration of Cho about March 2018, the declaration of Cho about April 12th on 2022 in those exhibits. But most importantly, they give no weight, no consideration to the August 2, 2018 decision and order of the trial court, where facts were reviewed and some facts were established. I quote the DNO. 2016, plaintiffs sought to modify the character of the ABT development. Defendants filed the objection to the amended HPR. Page 10, the court finds that plaintiffs carry their burden of proving defendants' unimmunized conduct with clear and convincing evidence. The evidence was already in the record. That's why I argued in the opposition. Law of the case, issue preclusion. This has been litigated. The opinion 2020, which confirms, approved, and expanded the DNO that denied the anti-SLAPP motion. Beyond that, they raised, how did ABC raise, I say, how did ABC raise or show no abandonment? Never. They never brought that. But yet they put breath to those words here in this court. Only the court below, in response to the Rule 59 motion, even said that. Your Honor, Justice Carbolito hit the nail on the head. You only respond to arguments actually raised. Judges will look at you quite negatively in a trial court if you start arguing out of paranoia. Oh, this, that, complaint.
But there's summary judgment motion if you look at their summary judgment motion, it did address more than just the right of the refund,
So,
right? I mean, it did, their summary judgment motion specifically said that the courts weren't willing to find waiver in circumstances which wasn't clear and compelling, and ABC did not clearly and unambiguously waive the right to participate in all GLU proceedings in perpetuity.
yes, Your Honor, they said that.
Right.
And we responded to that. And we used our brief to oppose that. And we cited, among other authority, the DNO of 2018. This found for evidentiary reasons they had waived it. We wrap up,
And-
Your Honor.
Yep,
Sorry.
go ahead. Well, you have 10 seconds.
Sure. Our conclusion in our reply brief filed July 1, 2024 sets out our 4 requests for remand and reversal.
Right.
Thank you, Your Honor.
Thank you, Mr. Berman. Thank you, Mr. Thompson, for excellent arguments from both of you. The court will take the matter under advisement. We'll issue a written decision and will now stand adjourned.
All right.
We have another matter, so we'd appreciate it if you could clear out quickly. I'm sorry.
Yes, Your
A
Honor.
little behind, and that other argument went longer than expected.